Chandrachud to please address the conference.
Namaskar. Honorable Prime Minister Shri Narendra Modi ji, Union Minister for Law and Justice Shri Arjun Ram Meghwal, my very distinguished colleague Justice Suryakant, the Attorney General Shri Venkatramani, the Solicitor General Shri Tushar Mehta, Dr. Shivakumar, President CLEA, Attorneys General, Solicitors General from the Commonwealth countries, visiting judges, Vice Chancellors, professors from law schools and students. I extend my sincere gratitude to the Office of the Attorneys General and Solicitors General of India, the Union Ministry of Law and Justice, and the Commonwealth Legal Education Association for organizing this conference of immense promise and relevance. As we convene here today and interact with persons of the legal fraternity from across various countries, particularly from the global south, we see numerous similarities and differences. But we are all bound together by a shared commitment to the pursuit of justice. The aim of this conference strikes at the heart of our collective endeavor to foster collaboration between officers of the court entrusted with the responsibility of justice administration. In today's rapidly evolving world, characterized by an array of pressing issues, the need to fortify institutional capacity is more urgent than ever before. This event is not merely a congregation of legal minds. It is a strategic alliance, a noble endeavor towards a more just legal system globally. As the inaugural speaker, I'm compelled to underscore the significance of global collaboration and trust building in addressing the diverse cross-border challenges to justice delivery. The Sustainable Development Goals serve as a universal call to action to end poverty, protect the planet, and ensure prosperity for all. These goals resonate deeply with our core constitutional principles of justice, equality, and human rights. These goals are not specific to just India. They are an intrinsic part of our legal systems. But achieving these goals requires collective action on a global scale. By fostering partnerships and sharing best practices, we can amplify our impact and pave the way for a more sustainable future. The legal community plays a crucial role in translating these goals into action by utilizing its expertise to navigate the complexities of law and governance and ensuring that justice and sustainability go hand in hand. One crucial aspect of shaping this future lies in the realm of legal education. Globally, we are witnessing a paradigm shift from textbook-oriented teaching methods towards a more practical-based approach to legal education. While traditional legal education has focused primarily on theoretical knowledge, there's a growing recognition of the importance of practical skills in preparing students to the realities of legal practice. Law schools are increasingly incorporated experiential learning opportunities such as moot court competitions and internships into their curriculum. These initiatives provide students with a hands-on experience and real-world insights, equipping them better to navigate the complexities of legal practice. This is reflected in the countless international moot court competitions which are conducted by various colleges in different parts of the world, including India. Moreover, the emerging trends in legal education, such as the integration of technology and interdisciplinary studies, offer exciting opportunities for innovation and collaboration. However, as we strive to modernize legal education, we must also confront the question of equitable access to legal education. Entrance tests for admission to law schools must not be exclusionary of the socially marginalized. We must ensure that our admissions processes are fair, transparent, and inclusive. This necessitates a holistic approach towards admission and recruitment that considers not only academic performance, but also factors such as socioeconomic background, diversity, and life experiences. Courts not only refer to the jurisprudence evolved by courts of other jurisdictions while deciding questions of constitutional importance, but also refer to the best practices on the administrative side. In the past year, the Supreme Court of India has hosted members of the E-Committee of the UK courts and judges of countries across the world belonging particularly to the Shanghai Cooperation Organization, SCO countries, where we discuss the best practices for the administration of justice. Our interactions range from discussions on the interface of technology and justice delivery mechanisms, and the presence or absence of statutory timelines for pronouncement of judgments once they are reserved by judges. I remember that when I drafted the white paper on reforms to the clerkship recruitment process in 2021 of the Supreme Court, before I took over as Chief Justice of India, my team of judicial law clerks and I studied the process of recruitment of law clerks in various jurisdictions. We identified the best practices in various countries and proposed a reform of the process which would ensure equality and increase diversity of applicants. At this conference, focused on law officers, it is pertinent to consider their pivotal role in upholding the ethics in legal practice. Law officers serve as a primary point of contact between the courts and the government, representing not only the government as an institution, but also the various departments and officials within it. The Attorney General and the Advocates General are posts envisaged under our Constitution. Several other law officers also represent the Union and the states, including the Solicitor General, Additional Solicitor General, Additional Advocates General for the states. The Supreme Court has repeatedly emphasized that law officers and professionals should not only assist the administration of justice, but also uphold the honor of the legal profession through exemplary conduct from both within and outside the courtroom. Ethics in legal practice encompass a wide range of principles, such as offering valuable insights into decision-making. Virtue ethics, for instance, underscores the importance of cultivating moral character and pursuing excellence in every aspect of legal work. In the context of the legal profession, this translates into a commitment to integrity, honesty, and professionalism in all endeavors. A crucial aspect of executive accountability rests on the ethical conduct and responsibility of law officers, who function not only as representatives of the government, but also as officers of the court. The eminent jurist, Nani Palkhiwala, wrote to Mr. Soli Sorabji on his appointment as Attorney General for India, and he said, "The greatest glory of the Attorney General is not to win cases for the government, but to ensure that justice is done to the people." Law officers bear a greater responsibility in upholding ethical standards compared to private practitioners, given their role as guardians of the rule of law. An exemplary figure in this regard is the late Soli Sorabji, a former Attorney General, who during his tenure demonstrated a commitment to justice by advising the Union when it lacked a valid legal case. It is imperative that law officers remain impervious to the polity of the day and conduct themselves with dignity in court, ensuring the integrity of legal proceedings. Simultaneously, we need to recognize the significance of cultivating a shared commitment to justice. Recent initiatives of the Supreme Court of India, such as the implementation of a standard operating procedure, SOP, guiding courts in summoning government officials, underscores the laying down of guidelines in this regard. This ensures a smooth code of ethics is formulated by judges in summoning government officials, and they are not summoned arbitrarily. The SOP emphasizes the imperative of treating government officials with dignity and respect in courts, discouraging disparaging remarks based on appearance or attire unless there is a violation of the dress code. Importantly, it cautions against leveraging the power to summon officials as a tool to pressurize the government, emphasizing that such actions should be reserved for circumstances crucial to the administration of justice. This collaborative approach involving legal officers, government officials, and the judiciary reinforces the ethical underpinnings of executive accountability while fostering a culture of mutual respect and cooperation within the justice system. Finally, as we stand at the intersection of tradition and innovation, technology emerges as a powerful force for justice. While it promises to enhance the speed and accessibility of justice, we must navigate carefully. The deep-seated structural and financial hierarchies within our societies in the global south demand consideration to ensure that technology does not inadvertently precipitate existing problems. modernizing courtrooms and facilities is as crucial as bolstering overall infrastructure, ensuring that technology serves to enhance transparency and accountability and not to perpetuate opacity and inequality. Technology should bring about a transformation, not just automation. Dr. B.R. Ambedkar, the architect of the Indian Constitution's insight that law and order are the medicine of the body politic, and when the body politic gets sick, medicine must be administered. This underscores the importance of thoughtful administration, especially when introducing technological innovations in the legal system. The eCourts project, for instance, aims to leverage technology to improve access to justice for all citizens. However, we must ensure that technological solutions are designed keeping in mind equity and inclusivity, taking into account the diverse needs and capabilities of all our stakeholders. In closing, let us embrace the challenges before us with optimism and resolve. Together, we can forge a future where justice knows no bounds and where the rule of law reigns supreme. Thank you. Namaskar.